The next matter to come before the court this morning is Children's Hospital versus William Paluch. Paluch. Ordinarily, both sides have 15 minutes to argue. It's my understanding that the appellee has waived. That means you have 15 minutes to argue today. You may use the time as you see fit. We've read the briefs and we're ready to proceed when you are.
Okay. May it please the court, I am William Paluch, the defendant appellant in the case before you. Since I am pro se, I shall refer to me, the appellant, in the first person. I was burned on June 4th, 2008. I went to the emergency room at Children's Hospital. The on-duty nurse was Heather Nepper, whom I dealt with. I said when I went into the emergency room, I made it very clear that I had no insurance and was on disability. She gave me a guarantee of payment form. I said I would not accept treatment if I had to guarantee payment. I was going to leave. She convinced me to stay by saying I would be treated without payment required and do not fill out the form for guarantee of payment. I then consented to treatment under clear understanding that I would not be required to pay. In 2010, Children's Hospital filed a case against me in Barben Municipal Court. The complaint stated that my son received treatment for which I did not pay. However, during pre-trial, I told the judge my son never went to the emergency room on that day, and it was me that went to the emergency room. The complaint was then amended to name me as receiving the treatment. The case was erroneously decided in favor of Children's Hospital. But upon appeal from this court, the judgment was vacated. The case was dismissed. The 9th District Court of Appeal ruled that there was judicial error in that case and remanded it back to Barben Municipal Court. The case was dismissed. In 2013, a new complaint was filed by Children's Hospital alleging that I received treatment from Children's Hospital and I incurred a liability. During the civil process, I filed for discovery and requested contact information for Heather Nepper and a clean copy of a guaranteed payment form. The form that was introduced into the trial court was a form that had a sticky note on it. And whoever put this in the trial court, nobody knows who put the sticky note on this piece of paper. But I, during discovery, asked for a clean copy with no stick-up notes on it. My request was denied in discovery. I asked also for how Heather Nepper could be reached so that I could do a deposition, whatever. That request was denied. I also asked the court to compel.
Was she still working for Children's Hospital at that time, do you know?
Pardon?
Was Heather Nepper still working for Children's Hospital at that time when you asked them?
At that time, yes.
She was?
She was. At that time, she was. I received no discovery, objected at the hearing, and made an oral motion to compel, as well as a written motion to compel. That's an oral and both a written motion. Discovery was denied, and we proceeded to trial. At trial, Children's Hospital did not produce any witnesses that could testify as me receiving treatment upon the condition which treatment was accepted by me. I testified and was the only witness that had firsthand knowledge that Heather Nepter introduced me to accept treatment without a requirement to pay. I testified that I refused to sign any guarantee of payment form which was consistent with me receiving treatment without an obligation to pay as put forth by Heather Nepper.
Did you make any effort to try to find Heather Nepper?
I do have a little bit.
Did you make any effort yourself to try to find Heather Nepper?
No. I was relying on getting the information from the other attorney. You know, I put in a motion for discovery. That discovery was denied.
At the time of trial, though, was she still working for Children's Hospital?
During the trial,
At the time the trial started, was she still working for Children's Hospital at that time?
yes, when the first trial,
No, I'm talking about in 2000.
oh, this trial,
Yeah.
I found out, and I will get that, I will touch on what you're asking, because there is a long story to Mrs. Nepper. Mrs. Nepper ended up stealing drugs from Children's Hospital. And she was indicted on them charges. And the prosecutor tried to sentence her to jail time. This case ended up before the 9th District Court of Appeals. And subsequently, she received treatment instead of prison time. And I will touch base again on my notes here. After hearing all evidence, the magistrate, I testified that I refused to sign a guarantee of payment form which was consistent with me receiving treatment without an obligation to pay as set forth by Heather Nepper. After hearing all the evidence, the magistrate ruled in favor of Children's Hospital with her finding of facts, including that it was my son who received treatment. If you go to the magistrate's decision, please note how many times they mention my son's name in getting treatment at Children's Hospital. How could a judge write a decision from a trial with false sets of facts? The judge most likely did not write it, but the same incompetent attorney that in 210 wrote the same false sets of facts. How could a presiding judge approve a magistrate's phony decision? Why did it take nearly 4 months for the judge to deny my objections to the magistrate's decision?
Did you file a transcript when you filed your objection?
Did I file what?
Did you file a transcript of the hearing in front of the magistrate when you filed
Yes, I did.
objection?
Yes, I
There
did.
was a transcript filed.
Yes. It took that long for the judge to develop enough nerve to continue the fraud in this case and rule in favor of Children's Hospital. The message is clear. Children's Hospital wants what they want and won't be stopped by evidence or a judicial process. With the same attitude by Barberton Municipal Court, fundamental justice requirement prevailing party to have a preponderance of the evidence was scrapped. What I'm trying to say here is that I was the only one in the emergency room that knew firsthand what took place between Heather and myself. The only witness that the plaintiff brought forth was a bookkeeper. And during cross-examination, I asked the bookkeeper, I says, do you have firsthand knowledge of what took place in the emergency room between Mrs. Heather Nepper and myself? And she says, no, I did not. So that's the only witness they had. So the weight of the evidence should have been in my favor because I was the only key witness that knew what transpired at the emergency room. I think that's very important. I had the only evidence as to the conditions of me receiving treatment without payment being required. Children's Hospital had no evidence to counter that. Produced no witnesses in Heather and Nepter upon request, and could not even produce a clean guarantee of payment form, but one that was a copy which was partially covered by a sticky note. The sticky note stated that I would arrange for payment later. I never said that to anyone. And under those circumstances, I would have left the emergency room and not received treatment. The sticky note had an unknown author and no testimony to support its authenticity. Conclusion. As it turns out, attorney claimed that he had no record to contact Heather Nepper. I later learned through a friend that Heather Nepper was charged with stealing drugs from Children's Hospital and was indicted and found guilty. Her case was appealed as she sought treatment in lieu of jail time. The prosecutor fought it, and this court ruled in her favor. How could Children's Hospital not know how to find her? That is...
Well, she wasn't employed by them at that time, though.
What's that?
She wasn't employed by them once she got caught stealing from them, right?
That's correct. That is correct, but when I asked in my discovery to produce where Mrs. Heather was, they couldn't produce anything about her. But the attorney flat out lied. He knew exactly in this high-profile case where she could be located, where she could be found. But he refused to give me that information.
Which high-profile case?
Pardon?
Which high-profile case are you talking about?
Where she was caught stealing drugs.
Okay, but she was no longer employed by Children's Hospital at that time.
However, her case did go forward.
And you couldn't have found that information out yourself?
I didn't know at the time. I found that information when I was doing my brief for this court, is when I found out that information. That information was hidden from me. And the attorney for the Children's Hospital knew about it. I'm convinced he knew about it, but he hid that. How could Children's Hospital not know about how to find her? That is a fraud. There's tax records, there's case reference through the prosecutor's office, or her own counsel could have located her. Somehow this fraud upon the court goes without acknowledgement and adds to the chaos of justice in this case. Based upon the ridiculous pretense justice in the Barberton Municipal Court, in this case, I am asking this court to reverse the decision of the trial court as clearly on the weight of the evidence and inducement of Children's Hospital represented by Heather Nepper is by the preponderance in my favor. Do you have any other questions?
Seeing none.
But how could I go on with discovery when I was denied just discovery, fairness? was denied that. To me, that shouldn't be tolerated by this court. And it shouldn't have been tolerated in the lower court. I feel as a pro se litigant that I was denied fairness. And I'm just asking this court to weigh the evidence and make their decision on that evidence. I thank you for listening to me.
Thank you very much. Court will take the matter under advisement. We will issue a written decision. It will be mailed to both sides, but also posted on our website and the Ohio Supreme Court website.
Thank you.
you.